Welcome to the story of justice is a process. All right, everybody, welcome to the story of this channel and the man behind this channel and the individual that inspired this channel and is, in my opinion, quite possibly one of the greatest legal minds that the world has never known about, unless you're inside my local town or in the state of West Virginia and you were around in the years of uh, between 1973 and 1996. Again, if you live in my little small town, you're going to know about him. You can go downtown and drop my name because I share his name, and there will be people who will talk about this legal phenom, this legal mind, this incredible individual who was helping everyone, eh, whether you had money or not. And that individual's name is Stephen M. Askin. And he is the genius behind Justice is a Process. He is the inspiration behind this channel. He is why we watch. He's why I'm inspired to watch. And he's why I hope you will be inspired to watch after you learn about his career, who he is, and what he did in his lifetime. And you see the memoriam logo that we have up there, 1948 to 2024, because unfortunately my father passed away in February of 2024, February 29th to be exact. And unfortunately, it was 3 days shy of making his debut on the show here and coming on live with me to talk with you. And all of the original plans that we had went up in smoke, and we recalibrated and have come today to present what we're doing today, which is bringing you the criminal justice system and giving you the opportunity to watch it and trying to add perspective and trying to add uh, education and context to the criminal justice system in the cases that you're seeing broadcast live on YouTube daily. So this will hopefully give you greater context as to who I am, who my dad is, and what the basis of this channel is all about, and what you're part of when you come to this channel to watch the criminal justice system unfold. I will be presenting uh, his career to you um, in episodes like this that you're going to see. My grandmother captured my father's career in 40 photo albums filled with every newspaper article ever written about my father through her death in 1995. So and again, it kind of unfortunately, my father's active legal career ended in 1996. You will learn all about that. You will get taken on this journey, and you will learn about who he is, what he stood for. You will learn the positives. You will learn about the flaws. You will learn about the story of the man who dedicated his life to ensuring fairness and due process for all, regardless of your socioeconomic background, your race, your religion, your sex, your gender, your sexual orientation. He did not care. He believed everyone had a right to a fair justice process. And that was why he committed himself to the profession of becoming a defense attorney. At one point, he was going to become a police officer. And you'll hear that because we have interviews that he did. We have, like I said, every case that every time he ever made it in a local paper, my grandmother clipped it and put it in this binder. And we're going to be bringing those articles to you. And we're going to be bringing the story narrated by myself, reading to you around the story behind the articles that we choose to present. We're going to be presenting this in chronological order. So tonight we're going to talk about the beginning, and we're going to talk about how my dad's career began and the initial cases he took on. And you're going to see that he came out the gate principled and fighting, and and you're going to see exactly why the system came at him and came after him. And you're going to see why today justice as a process sits watching and hopefully ensuring by bringing the ability to watch that people's due process rights and fairness, and that the justice system is operating fairly, regardless of who the person is, the crime they committed. Everyone has a right to a fair process, and we are going to do our part, as my dad said was the most important thing to do, and that was watch. It's what my grandmother did, is she watched every single one of his trials, every single one of these cases. She traveled and watched. And we are going to continue doing the same, watching and hopefully ensuring and doing our part in reporting when things are not done properly. But anyways, without further ado, let's get into the story. Now, I'm going to be doing these as live premieres, but if there's a lot of interest, if there is interest in sitting down and having some live question and answer sessions, I will do those to answer your questions about my dad and who he is. And we'll dig deep into the extensive knowledge I have of his career. I'll even get the binders out, and we can go deeper into things and answer the questions that you want to hear and know about him. So without further ado, though, let's jump in to the beginning. Let's get started as you now learn the origin story, the background behind the guy you've heard about in the descriptions of the videos. You've heard me talk about him during lives. You've heard me reference him. And you're going to get to hear the story told by his son. You're going to get to hear the story told by his mom through the newspaper clippings that she collected. And you're going to get to hear the story told through my father in the stories he told me and the things I experienced as his son as he journeyed through his career as a absolute due process legend, fighting for people's rights. Anyways, without further ado, let's get started. So the beginning, Stephen M. Askin's first cases and the foundation of a constitutional fight. Before the contempt conviction, before the disbarment, before the criminal prosecution for helping people from a coffee shop, there was a young attorney in Berkeley County, West Virginia, who was already showing the system exactly what they would later try to destroy. Introduction: understanding what came before. Most people who know about Stephen M. Askin know the story of what the system did to him. They know about the 1994 contempt conviction when he refused to betray attorney-client privilege and violate the Fourth Amendment. They know about the 1998 disbarment. They know about the 2009 criminal conviction for unauthorized practice of law when he helped people understand their rights from a coffee shop. But here's what they don't know. They don't know that every single principle that would later get him destroyed by the system was already there in 1973 when he walked out of West Virginia University College of Law and started practicing. They don't know that the first time he stood in a courtroom as a defense attorney, he was already challenging police conduct. They don't know that before he even had his law license, he was organizing prison reform efforts based on a simple philosophy: hours and people, not dollars and cents. The newspaper clippings you're about to read through tell a story the system wishes had been forgotten. They show a young attorney who immediately understood something most lawyers never grasp. The system only works when someone forces it to work, when someone watches, when someone questions, when someone refuses to let constitutional protections become theoretical concepts that only apply when convenient. These aren't just old news articles about a few cases from 1973 and 1974. This is the origin story of the fight that continues today through justice is a process. This is proof that Stephen M. Askin didn't become a constitutional advocate because the system came after him. He became a target because he was a constitutional advocate. And that changes everything. May 1973, the beginning. The first clipping is simple. It's almost mundane. It's an announcement that appeared in a local West Virginia newspaper sometime in May or June of 1973. And there you can see, guys, that's my dad right there. Stephen M. Askin. Maybe you can see a little resemblance. I don't know. But there he is, young man. Attorney Stephen M. Askin with Jerome Radosh in the practice of law. The text tells us the basics. Stephen M. Askin, originally from Silver Spring, Maryland, graduated from Lock Haven State College in Lock Haven, Pennsylvania in 1970. 3 years later, in May 1973, he graduated from West Virginia University College of Law. Before rejoining Jerome Radosh in private practice, he had worked for the state of West Virginia as a juvenile supervisor at West Virginia Industrial School for Boys in Pruneytown. Think about that for a moment. His first professional experience wasn't clerking for a judge or working at a prestigious law firm. It was working with juveniles in the system. Young people who had been failed by society, failed by their families, failed by the very institutions that were supposed to protect them. The announcement states that he would practice at the Charlestown office at 116 East Washington Street, but would also hold evening and weekend hours by appointment at the Martinsburg office at Berkeley Plaza. Now, this is significant. Evening and weekend hours. Now, most attorneys just starting out are trying to establish 9-to-5 practices. They're trying to build a client base that can afford their rates. They're trying to position themselves for success by the metrics the legal profession uses to measure success. But Stephen M. Askin was offering evening and weekend hours. He was making himself available to people who worked during the day, people who couldn't take time off to meet with a lawyer, people who needed help but didn't have the luxury of arranging their lives around courthouse hours. This wasn't an accident. This wasn't just good customer service. This was a statement about who he intended to serve and how he intended to practice law. He graduated in May 1973, and he immediately went to work in the philosophy. And this philosophy carried my dad through his entire career. It was hours and people, not dollars and cents. I repeat that, hours and people, not dollars and cents. But before we get to the courtroom cases, we need to understand what was driving him, because there's another article, one that reveals something crucial about who Stephen M. Askin was before he even became a licensed attorney. This article is titled, Hours and People, Not Dollars and Cents. Prison Reform Group Awaits. Go ahead. And it was written by Johanna Fisher. It tells the story of the Prison Reform Action Group, known as PRAG. 2 days after the Attica prison affair, the 1971 uprising that resulted in 43 deaths, an agricultural graduate student named Sherwood Morgan attended a Council of Churches meeting where conditions in penal institutions were being discussed. A few days later, Morgan went to a panel discussion about the Attica affair, and he talked with Stephen Askin, then a university law student, about positive ways citizens could work within penal institutions to assist in making life better for prisoners. Read that again. Steve Askin was still a law student when he starts organizing prison reform efforts. Now, this article explains that Morgan and Askin become the co-organizers of the campus and community-involved Prison Reform Action Group, PRAG. And here's the quote that tells you everything you need to know about Stephen M. Askin's philosophy. I will stress that hours and people are the basis of PRAG, not dollars and cents. There will be no tax money involved in our activities. Hours and people, not dollars and cents. This wasn't about building a nonprofit that could pay staff salaries. This wasn't about getting government grants. This wasn't about creating an organization that could sustain itself through foundation funding. This was about showing up. This was about giving time. This was about treating people in the system like human beings who deserved help. And I submit to you, ladies and gentlemen out there watching this right now, understand that is the principles of justice as a process. It's about showing up, watching. And that's what my dad was about. And that's what this is about. That's what this channel is about. It's not about dollars and cents. It's about hours and people. It's about watching. It's about watching the cases no one cares about. It's about advocating for the people no one cares about. It's about showing up when no one else will show up. That's what this is about. That's what my dad was about. And that's what my dad's career was about. The criminal defense cases where philosophy meets courtroom. The Thomas Harden case, challenging police conduct and winning on appeal. One of the earliest reported cases involves Thomas E. Harden, a 26-year-old man charged with multiple offenses following an altercation stemming from a motor vehicle charge. Harden appeared in city court on charges related to his vehicle registration plate not being clearly visible because of mud, disorderly conduct, and opposing an officer. Represented by attorney Stephen M. Askin, Harden pleaded guilty to the license plate charge and forfeited a $31 bond, but he contested the other two charges. Now, the incident in question occurred about 1 a.m. Sunday in front of Harden's home. Officers Lieutenant Blaine Brumbaugh and Sergeant Perry Smith testified that they warned Harden to clean off his obscured license plate. But when Harden refused, saying he had on his good clothes, the situation escalated. And according to testimony, Harden said, "I'm no darned bleep. I'm not going to clean them off." The witness then testified that Lieutenant Brumbaugh took Harden by the arm and told him he was under arrest for disorderly conduct. Harden said he pulled away from the officer, Sergeant Smith, hit him across the face with a flashlight, and then with his nightstick. At the conclusion of the testimony, defense attorney Stephen M. Askin asked Municipal Judge Oakley Seibert to find his client not guilty because Harden had not been disorderly prior to his arrest on the disorderly conduct charge. I want you to read that again. Askin's argument was that his client couldn't have been arrested for disorderly conduct if he hadn't actually been disorderly when the officers arrested him for disorderly conduct. Judge Seibert ruled against them, but Stephen Askin didn't stop there. You can see, city case appealed. He took the appeal to circuit court, and on June 26, 1974, the jury returned a not guilty verdict. A verdict of not guilty was returned by a jury late yesterday afternoon in the Berkeley County Circuit Court in favor of Thomas E. Harden, who had previously been found guilty on several counts in Martinsburg City Police Court. The circuit court trial put the full story before a jury. City Attorney D.H. Rogers Jr. represented the city. Stephen M. Askin represented Harden. And after hearing all the evidence, after deliberating for about 1 hour, the jury found Harden not guilty. This is what effective criminal defense looks like. A municipal court judge convicted Harden, and everyone expected that to be the end of it. But Stephen M. Askin took the court case to circuit court, put the police conduct on trial, presented the full story to a jury, and secured an acquittal. One of his first cases as a licensed attorney, Stephen M. Askin took on the police department, appealed an adverse ruling, and won. And that, ladies and gentlemen, is what would define my father's career. That is a story my father shared with many young attorneys, because that is what drove him. Because he was not going to let the system. He was not afraid to appeal. He was not afraid to take it to the next level. And he was not afraid to fight when he thought there was something to fight for. He was not afraid to fight when he felt someone's rights were being violated. And as you can see, he did so in that case, and he won when no one thought he would win. Now we're going to move on to the Ernest Gray robbery case, fighting even after the verdict. Another early case shows Askin taking on serious felony charges and demonstrating that the fight doesn't end with a guilty verdict. Edward C. Gray, also referred to as Ernest C. Gray, was charged with robbery. The trial continued in Berkeley County Circuit Court before a jury and Judge Vance E. Sensendiver. Most of the state's witnesses had given testimony as to identification of Gray as one of two men who got in a taxi on the night of October 29, 1973, in front of Angie's Pizza Parlor on Winchester Avenue. Gray and a companion were alleged to have robbed the driver, Clarence Roman, after driving to the Bunker Hill area and then stealing the taxi. The article notes the witnesses are being cross-examined by attorney Stephen Askin, counsel for the defendant. After 2 days of trial, the jury deliberated slightly more than an hour before returning a verdict of guilty against Ernest C. Gray. He was found guilty of stealing approximately $22 from Clarence Roman, a taxi driver, and then taking his automobile. But here's what matters. Attorney Stephen Askin, counsel for the defendant, immediately made a motion to set aside the verdict and to grant a new trial. Askin also moved for a pre-sentencing investigation of his client. This shows the complete picture of Stephen M. Askin's defense work. He cross-examined the state's witnesses. He made the state prove its case. And when the jury returned a guilty verdict, he immediately filed post-trial motions to continue the fight. The case went to trial in late October 1973, just months after Askin graduated from law school. He was handling a serious felony robbery case, conducting a 2-day jury trial, and filing sophisticated post-trial motions. The Herbert W. Smith case, the armed camp courtroom. But the most revealing case in these clippings is the prosecution of Herbert W. Smith for the shooting of Deputy Sheriff George Shackelford. This case shows Stephen M. Askin at his most principled, and it foreshadows everything that would come later. And here you can go. If you want to freeze the video right now, you can read the article. I'm going to put it up on the screen so that you can see it behind me. But Herbert W. Smith went on trial before a jury and Judge Vance E. Sensendiver in Berkeley County Circuit Court on a felony charge of malicious wounding of a deputy sheriff. Smith was charged with twice wounding Deputy Sheriff George Shackelford near Allensville on the evening of May 18, 1973, just weeks after Askin graduated from law school. Prosecuting attorney Earl W. Weller said that Shackelford and Deputy Sheriff Grayson Davis were attempting to serve a felony warrant on Smith at the time. Weller said that Smith fired a number of shots, one bullet striking Shackelford in the right temple and another striking him in the groin and leg. Attorney Stephen M. Askin, counsel for the defendant, said that Smith fired in self-defense after Shackelford had fired 4 shots. Askin also brought out that Shackelford and Smith were related and argued over the serving of the warrant before the shooting started. But here's the moment that defines Stephen M. Askin's approach to criminal defense. Before the start of the trial, Askin objected to what he termed the armed camp atmosphere of the courtroom, noting that there were some 5 armed deputies, a constable, and a state police officer present. Acting on this objection, Judge Sensendiver reduced the security to 1 deputy at each public door to the courtroom. I want you to think about what this means. A deputy sheriff has been shot. The defendant's on trial for malicious wounding of that officer. Every law enforcement officer in that courtroom wants to see Smith convicted and sent to prison for a long time. They packed the courtroom with armed officers to send a message to the jury, and this man shot one of us, and we want justice. Stephen M. Askin stood up and called it what it was, an armed camp atmosphere designed to intimidate. And he didn't just complain about it. He moved for it to be remedied, and Judge Sensediver agreed and reduced the security presence. The article notes, in an unusual procedure for the local court, everyone was searched for weapons before being allowed to enter the courtroom, which was nearly filled with spectators. Stephen M. Askin challenged it, and he got the judge to scale it back. The jury returned a verdict after about 2 hours. This is crucial. Smith had been charged with malicious wounding and felony. The jury convicted him of assault and battery, a misdemeanor. And remember, he was charged with malicious wounding of a police officer. And here's the article. A verdict of guilty of assault and battery was returned against Herbert W. Smith by a jury yesterday evening in the Berkeley County Circuit Court after about 2 hours of deliberation. Smith had been charged with malicious wounding, a felony in the shooting wounding of Deputy Sheriff George Shackelford in an incident last May 18th in the Allensville section of the county. Judge Vance Sensediver withheld sentencing on the assault and battery misdemeanor, pending a later ruling on motions to set aside the verdict and grant a new trial, as made immediately by attorney Stephen M. Askin, defense counsel. In rebuttal testimony closing out the trial yesterday afternoon, Mr. Shackelford's the wife of the wounded officer and niece of Smith, denied she'd offered in a telephone conversation to have the criminal charges dropped if Smith paid $25,000. She said her conversation with Smith over the phone involved an out-of-court settlement of the civil suits brought by Shackelford against Smith. Earlier in the trial, Sheriff Lyle Catlett, was called as a defense witness, testified he'd overheard a telephone conversation between Smith and Mrs. Shackelford. Catlett indicated that he felt the conversation regarding the $25,000 payment was in regard to dropping criminal charges. Also, as a rebuttal witness yesterday afternoon, Chief Deputy Sheriff Harold Downey testified that when he examined Shackelford's pistol shortly after the shooting, he found only 2 bullets had been fired. Smith had testified Shackelford fired 4 times and that he, Smith, had returned to fire in self-defense. 1 bullet struck Shackelford in the right temple and another one in the groin. Prosecuting attorney Earl W. Weller represented the state in the trial, and Harold Dent served as foreman of the jury. This is a defense victory. The jury rejected the felony charge. Judge Vance Sensediver withheld sentencing pending later rulings on a motion to set aside the verdict and grant a new trial, as made by attorney Stephen M. Askin, defense counsel. Even after the verdict, Askin fought on. My dad fought on. He filed motions to set aside the verdict and grant a new trial. Let's be clear about what Stephen M. Askin accomplished in this case. He challenged the intimidation tactics in the courtroom and got the judge to reduce them. He presented a viable self-defense theory. He got the jury to reject the felony charge of malicious wounding. He introduced his evidence suggesting the prosecution might be motivated by a civil dispute over money, and he filed post-trial motions to continue fighting even after the verdict. This is masterful criminal defense work, and this is from a lawyer who had only been licensed less than a year. And remember, the victim in this case was a police officer. There are a lot of attorneys in 1974 who would have never dared put themselves at odds with the Berkeley County Sheriff's Office in a small town in West Virginia. What these cases reveal? The pattern. When you look at these early cases together, a pattern emerges. And it's the same pattern that would define Stephen M. Askin's entire career. Pattern 1, he challenged official misconduct. In the Thomas Harden case, Askin challenged the police conduct. He argued that Harden hadn't been disorderly when arrested for disorderly conduct. He got testimony into the record about a police officer striking his client in the face with a flashlight and nightstick. He took the case on appeal to circuit court, and he won. The jury returned a not guilty verdict. In the Herbert W. Smith case, Askin challenged the armed camp atmosphere of the courtroom. He objected to the intimidation tactics of having 5 armed deputies, a constable, and a state police officer present during the trial of a man accused of shooting a deputy. This wasn't about hating law enforcement. This was about holding law enforcement accountable to constitutional standards. This was about ensuring that police officers and prosecutors followed the same rules as everyone else. Pattern 2, he defended the presumption of innocence. In the Ernest Gray robbery case, Askin conducted a complete 2-day trial, cross-examined multiple identification witnesses, and made the state prove its case. When the jury convicted Gray, Askin immediately filed motions to set aside the verdict and grant a new trial and move for pre-sentence investigation. The Herbert W. Smith case, Askin presented a vigorous self-defense theory and introduced evidence suggesting the prosecution might be motivated by a civil dispute over money. He got the jury to reject the felony malicious wounding charge and convict only on the misdemeanor assault and battery charge. He understood that the presumption of innocence isn't just a nice theoretical concept. It's a functional requirement of due process. The state must prove its case beyond a reasonable doubt. The defendant doesn't have to prove innocence, and a defense attorney's job is to hold the state to that burden. Pattern 5, he never stopped fighting. Even after the guilty verdict in the Herbert W. Smith case, Askin filed motions to set aside the verdict and grant a new trial. After losing the Thomas Harden Municipal Court case, he took the appeal to the circuit court and won a not guilty verdict from the jury. After Ernest Gray guilty verdict, he immediately filed post-trial conviction motions to set aside the verdict and grant a new trial and move for a pre-sentencing investigation. He understood that the fight doesn't end with a guilty verdict. Appeals matter. Post-trial motions matter. Pre-sentencing investigations matter. You got to keep fighting until every option is exhausted. And sometimes, if you fight hard enough and long enough, you win. The Thomas Harden case proves it. Municipal court conviction overturned on appeal, not guilty verdict in circuit court, complete vindication. The foundation. What 1973 teaches us about 1994 to 2010. Here's why these newspaper clippings matter so much. When Stephen M. Askin refused to testify in 1974 about privileged communications obtained through what he believed were Fourth Amendment violations, the system tried to paint him as a rogue lawyer who had gone off the rails. When they disbarred him in 1998, they tried to suggest he'd betrayed the legal profession. When they criminally convicted him in 2010 for helping people from a coffee shop, they tried to portray him as someone who couldn't let go of the practice of law. But these articles from 1973 and 1974, they tell a different story. They show that Stephen M. Askin didn't become a constitutional advocate because the system came after him. The system came after him because he was a constitutional advocate. From his very first cases, he was challenging police misconduct. From his very first court appearance, he was defending the presumption of innocence. Before he even graduated from law school, he was organizing prison reform efforts based on the principle that hours and people matter more than dollars and cents. The 1994 contempt conviction wasn't an anomaly. It was consistent with everything he had always done. He stood on principle. He refused to violate what he believed were constitutional protections. He wouldn't betray his clients even when a federal judge ordered him to do so. The 1998 disbarment wasn't about a lawyer who had lost his way. It was about a lawyer who had stayed true to his principles for 23 years, and the system finally found a way to silence him. The 2009 criminal charges for unauthorized practice of law weren't about someone who couldn't let go of being a lawyer. They were about someone who understood that helping people understand their rights is more important than having a license to practice law. The Berkeley County prosecutor who opposed his reinstatement in 2006 said she feared he would disrupt the legal system by training young lawyers the way he practiced. You know what? She was exactly right. The machine we're building. Justice is a process as the continuation. In 2006, when Stephen Askin, my dad, applied for reinstatement of his law license, he was recruited by Mountain State University to build West Virginia's first online law school. He would be the founding dean, training young lawyers, teaching constitutional advocacy. The Berkeley County prosecutor opposed his reinstatement, stating she feared he would disrupt the legal system by training young lawyers the way he practiced. They denied his reinstatement. They stopped him from building the law school. They prevented him from training that next generation of constitutional advocates. But they couldn't stop justice as a process. Through this YouTube channel, 77,000, actually today 82,000 plus subscribers and growing. We are doing exactly what that prosecutor feared. We're training people to think like constitutional lawyers. We're teaching them to question police conduct, to understand the burden of proof, to recognize when due process is violated. We're building a watchdog system that covers trials and holds the system accountable. Every video is a lesson in constitutional advocacy. Every title that calls out prosecutorial misconduct is teaching viewers to watch for it. Every description that explains legal concepts is training people to understand their rights. And every Justice Breakdown article is meant to show people how to analyze trial strategy and identify constitutional violations. We are not training law students in a classroom. We're training the public. Thousands of people every day are learning what prosecutors and judges don't want them to know. This is the machine they feared. This is what they tried to prevent when they denied his law license reinstatement. This is what they tried to stop when they criminally convicted him for helping people from a coffee shop, but they failed. And the beginning tells us everything. These newspaper clippings from 1973 and 1974 aren't just interesting historical documents about a young lawyer's early career. They're proof that Stephen M. Askin was always who he said he was. From his very first case as a licensed attorney, he challenged police misconduct. From his very first courtroom appearance, he defended the presumption of innocence. Before he even graduated from law school, he was organizing community support for people the system had abandoned. When the Berkeley County prosecutor said in 2006 that she feared Stephen M. Askin would disrupt the legal system by training young lawyers the way he practiced, she was describing the work he'd been doing since 1971. She was describing the cases from 1973 and 1974 where he challenged police conduct, questioned the armed camp atmosphere, and fought for every client like their freedom mattered. And she was right to be afraid, because that kind of lawyer, one who actually defends people, who stands on constitutional principles, who challenges the system's abuses, who never stops fighting, that kind of lawyer is dangerous to a system built on intimidation, shortcuts, and the presumption that most defendants are too poor and too scared to fight back effectively. Through Justice as a Process, we are building exactly what she feared. We're training thousands of people to watch the system critically, to understand their rights, to recognize constitutional violations, to demand accountability. We're doing it through educational trial covers, through detailed legal analysis, through watchdog journalism that holds prosecutors and judges to their oaths. Every video honors Stephen M. Askin's legacy, my dad. Not just because it carries his name, but because it continues the work he started 54 years ago when he organized a prison reform group on the principle that hours and people matter more than dollars and cents. These 1973 newspaper clippings show us the beginning of a 53-year fight for constitutional rights and due process. They show us a young lawyer who understood from day one that the system works only if someone makes it work. They show us the principle that would eventually get him destroyed 2 times by the system. But they also show us something else. They show us that those principles were worth fighting for. That standing on constitutional ground matters even when you stand alone. That helping people understand their rights is more important than keeping your law license. That the fight for justice doesn't end when the system tries to destroy you. It just takes new forms. The machine they feared is built. Stephen M. Askin's name will forever be on the minds of everyone in this system. Because we're not just covering trials. We're continuing a 54-year fight that started when a young law student decided that hours and people matter more than dollars and cents, and that prisoners deserve to be treated like human beings. And that fight didn't end when they took his law license. It didn't end when they criminally convicted him. And it didn't end when he died. It continues every day, through every video, through every article, through every viewer who clicks on a video, who learns to watch the system critically and demand constitutional accountability. This is justice as a process. This is Stephen M. Askin's legacy, my dad. And this, everyone, is only the beginning. We're just getting started. We're just getting started. So I hope you've enjoyed the first installment. I hope if you've made it to the end, I hope you've walked away with a greater understanding of what we're doing here on this channel, of what we've been doing, of what you've been doing, of what this is all about, of what this means, of who the creator of this channel is. And although he can't be here to tell you this, luckily, his articles, his son, and his impact that he's made will live on. And every time you click on a Justice as a Process video, you are helping to carry forward his legacy that he built in his fight to ensure that no matter who you are, no matter what your race, no matter what your socioeconomic background is, no matter what your sexual orientation is, no matter where you come from, that your rights matter and that you will get a fair shake and you will get a fair process and that justice will be a process and not an outcome for you. Thank you for watching tonight. Thank you for being here. If you're a subscriber, thank you for clicking. If you're a member, thank you for being there. Thank you for supporting the channel, and thank you for supporting this mission. It means everything to myself and my father as we continue the fight he started 53 years ago, 54 years ago. This is the story. We will continue telling it. We're going to continue to go through his cases. We're going to continue to go through his career, and you're going to get to know him. And you're going to get to learn about, in my opinion, one of the greatest legal minds you have probably not yet heard of, but you're going to hear about, and you've started to hear about tonight. So I'll see you guys in the next video. I'll see you in the courtroom. I'll see you in the chat. Stop in, say hi. I appreciate all of you. My dad appreciates all of you. Let the fight continue. And remember, justice always, always works better when we watch.